Mike, let's get started. What do you think?
Why
Oh,
not?
another pink shirt. Look at that.
Fight
You
me.
didn't get the memo?
I didn't get the memo. What am I doing? Hold
I'm
on.
gonna start wearing khakis too.
I could wear my pink jacket. It might be too much pattern though,
I'm gonna have to put a coat on now.
There we go, Mike. You ready?
I'm ready.
All right, let's talk about how to put a deal together in 2024. What did you miss in 2024 if you're just joining us today? You missed a lot. Mike, give us the quick summary on what happened in 2024 for real estate and realtors specifically. Quick, you got 10 seconds.
This will be about 4 hours.
Just a scream mic would work.
Uh, but I'll tell you, very interesting, Christian. The recent one that people are grappling with right now is that flood disclosure form. A lot of people are not aware or forgot that October 1, that flood disclosure form is mandatory.
Yeah, it is
Uh,
mandatory. There's a lot of new mandatory stuff that's going on, and I think it's important we put it all in one video, whether you like using NABOR contracts or if you like using a FAR bar or a FAR contract, there are a lot of changes. This so happened to correlate with a forms year or forms change year, update year that NABOR does every 2 years. So this was going to be changing anyways, but it actually changed quite drastically. I kind of regret being on the forms committee this year because of how much work it ended up looking like or ended up being. Um, I want to show everybody something really quickly. So yesterday I did this with a customer of mine, and I told him go on nabor.com to get started. Now, if you use FARBAR or FAR, you could still try and access this, or you can just use this video to see it. But I think it does a really good representation of all the changes, all the new forms that have come out specifically for the NAR settlement. So back in the spring, NAR agreed to a big settlement regarding some pending lawsuits. And so part of that settlement, we had to change our forms, we had to update our disclosures. And so you can actually see this right on the Nabor
Oh,
website.
I see the property specific one. That's new.
These are all new this year, but I love this because it's changes to Nabor contracts, NAR settlement, more forms coming.
Yeah.
It's going to be, there are more forms coming, but this is all that's changed. There is a lot. So if you are a Nabor member, if you have access to the website, I highly recommend you go here. Now, that this was somewhat foreign to the realtor that I was speaking to yesterday because she always used app files or some other vendor. But if you go right to Nabor website, you'll see this because I think it clarifies all the changes in one little section. Now, there are forms that changed that were not related to the NAR settlement, but this is where we got to start. We have to start here. So the big thing with the NAR settlement is that a buyer broker must have a written agreement with their buyer before touring a property. Um, Sounds simple, but the execution has been really challenging. The paperwork included in that, very challenging. And there's a lot to it. So really there's a balance here. And that's kind of our job is to help you decide what is legally required and then what else is out there? What more can you do? We want to establish the very least that you can do and then let you add on or do even better based on the circumstances. So it all starts there, the buyer broker agreement or some version of that. Now, Dad, is there a specified form that a buyer's broker has to use?
Nope.
They can
Some
use anything. It just has to have a couple of simple disclosures.
four elements. There's a recent Nabor seminar. You can go on their website with Marcy and I think Sean Gary that talk about how you can use the FAR forms, you can use these forms as long as they have the four elements. And Sean even goes so far as to say individual brokerages are coming out with their own forms. Those are fine as long as they have the four elements.
Yeah. So if you're looking at Nabor, you've got your broker compensation. Well, that's not the one we're looking at. We want the buyer broker
The
agreement
property specific.
specific. So that form is great if you're just trying to connect with your buyer who's a little hesitant to sign something else. You say, well,
Yeah.
let's just do one for this one property that we're going to go see, or these 6 properties we're going to go see this weekend. And then you've got the buyer broker exclusive agreement, which is way more expansive. It has a section on there where you limit it to a county or the entire state. Otherwise, those are the exact same forms. And then you have, if you look on the FAR and the FAR bar agreements, FAR has these forms, and the one that I thought was really interesting. So you've got
The touring agreement
I like that one. In fact, it's
It's
called
one
the
page. It's
Property
so simple.
Pre-Touring Agreement.
Yeah.
So that would satisfy the 4 required sections or 4 required things in that settlement. And it's, the big difference with the pre-touring agreement is that a buyer can always terminate it. They can fire you, they can say, no, it's not working anymore, and that agreement ends. But that's kind of how we've always used to do. We always used to do business. It was all loyalty and, just kind of working together. And if they no longer wanted to work with you, it is what it is. You might have clear cooperation to fall back on, but you didn't really have much else. So property pre-touring agreement, that's the minimum. It's a 1-page agreement. It basically lets you go tour the home with your buyer, and you can tell them openly, honestly, transparently, there's no real risk to you. We're going to go see the house. If it doesn't work out, we'll move on. You can, if you want to work with someone else, you're allowed to. And then Nabor and FAR also have that next level up, which would be the property specific buyer brokerage agreements. And I think FAR they don't have the property specific, but they have the next level up from there.
Well, they have the property specific. They also have the time specific, and then they have the exclusive. I forget the lady's name. She's on the Florida Real Estate Commission. She talks about this on the FAR
what is that one called?
website.
The property specific one.
How do you catch them?
Yeah, the titles kill me.
Let's see. They don't call it property specific, but let's see. Buyer.
Well, the pre-touring one isn't that? That's just time. Like you're meeting somebody Friday and it expires Sunday afternoon.
Yeah, they don't itemize it on that one. But either way, you've got the way I look at a buyer broker agreement, you have your minimum, which is the pre-touring or some version of that. Then you have your property specific one, or you could even put it at 0, and then you could amend it later. And then the best form that protects the realtor the most and allows them to show any property at any time with their buyer would be the exclusive buyer broker agreement. And FAR has several versions based on the relationship, the agency disclosures. So you have single agent, transaction broker, or no relationship. So you have 3 there versus Nabor has just the one buyer broker exclusive agreement. So it all starts there. It really does. If you want to work with a buyer, you have to start there. Good, better, best type thing. And Dad, you and I have done an article. We've done videos on this. Good, better, best. And really you just base it off of what you need for your business, for your peace of mind in working with someone. Mike, what are some of the pitfalls that you have seen regarding the buyer broker agreement? Some of the fun yet really scary stories.
The worst one, or one of the worst that I see, is someone tries to get signed after there's already a fully executed contract.
Yeah, that's scary.
no-no.
I don't like that one. Now, why is that a problem, Mike? Why does that matter?
Because they're supposed to do that agreement before they show a property.
Yeah.
And so obviously they showed well, not always.
Well, we'll talk about that too.
Yeah.
So on its face, this looks like a really bad thing because you have a sales contract dated Monday, and then they do a buyer broker agreement dated Tuesday. And you're like, wait a second, that buyer broker agreement's supposed to come before you even tour the property, let alone before they go under contract. Now, we've seen that that's a no-go. That's a killer deal. That doesn't work. But we also saw we had one situation like you mentioned, Mike, where the buyer never toured the property at all. It was sight unseen, never toured by the realtor, and so they actually made their offer and then did the buyer broker agreement after the fact. That was a really interesting one because you wouldn't think you could do that, but the facts all aligned that the real linchpin is touring the property, not going under contract. The facts have to support you, right? You certainly couldn't make up that fact pattern later because, there's with all the digital appointment reminders and the lock boxes, and you have all the different people that are involved in the deal. It's problematic. Now, one of the interesting parts that I was thinking about is I think I asked you in that scenario, has the buyer done their inspection yet? Because to me, inspecting the property could be deemed a touring. And luckily they hadn't, so we were able to move on. I think that realtor was still able to get compensation, but that was scary. Don't do that, right?
Well, the other one that we're seeing a lot, Christian, is where, and they mean well, but they're filling out the buyer broker agreement and they're not specific on the compensation. They might put in a range or whatever, and the intent is that no, the buyer needs to know what he's getting into. And
Yeah.
so you've got to be specific and you can't beat around the bush on that one.
Yeah, you can always amend it later, but you have to have a specific number in there, or you could do a property specific form and just do multiple. So if we're going to go see property one and it's paying this, do a property specific. And then if it's property two and they're paying something different, then you would do a different number for that one. So that would, if the reason people are doing it is because of that issue, then I think you just do property specifics or keep it at whatever you're charging and then you could amend it later.
The third scenario I've seen, Christian, is where a husband and wife are buying a property, but only one signed the buyer broker agreement.
Yeah, what did you decide on that, Mike?
You call me.
You tried, yeah, that's exactly what I did.
Yeah, and then what do you do? What's the answer? Is that
I,
okay?
I said yes. I had watched some video where people were going with that. Most people, like me, you, Christian, Mike, we have durable powers for our spouses. Wouldn't be the first time I signed your mother's name to anything.
Yeah. I just, even if they don't have a power of attorney, it doesn't bother me. You just have to have an agreement with the buyer, and the buyer is somewhat of a fluid definition there. I don't think it's an issue whatsoever. Just have whoever is touring with you, have them sign it if they want to add their wife later, or if they're adding their domestic partner at some later time, or they put it into their trust later. I don't think it matters. You just have to be able to draw a connection,
I mean, there's a legal fiction that a husband and wife are one person under the law. So, I go with that BS.
But I don't even that I don't mind if they're not married. I think you just have to get it as close as you can.
Yeah.
Go show it, and then you can always do an amendment later to add someone in. You could do an amendment. You may not even need it. It's totally up to your broker at that point. But the contracts are assignable most of the time, and so we're kind of
Oh,
predicting that this is
exactly. What
going
do
to
you do
change.
with an assignment on the day of closing when they're flipping it into a trust or an LLC? You could do another one, or it's not, they've already toured the property. So, if I go with if they say we can't do it, if they don't say we can't do it, you can do it in most cases, unless it's really egregious.
Yep, that makes sense. So, Mike, any other issues that came up?
The one that hasn't come up yet, and I'm surprised, but it will happen during season, I guarantee it, is where the buyer signs multiple buyer broker agreements with multiple agents. He goes around, hits all the open houses. They all get the buyer to sign. Say that is coming. I would bet the ranch on that one.
Yeah, and at that point, I always say buyers can hire multiple attorneys, buyers can hire multiple plumbers. They're just going to be paying multiple times. And that's obviously not ideal for the buyer, but it doesn't mean that you don't have a valid contract with the buyer. So, it's probably happening, but the agent who doesn't find the house and they know that someone else did, hopefully the agent would just kind of back off in that case. Really, we're here, we want to serve the customer. We don't want to, be enforcing contractual rights when we really weren't involved on that particular deal. Everyone has a different decision to make in that regard, but I think you really do have to look out for the best interests of the consumer where you can. Now, these contracts are also great, Mike. One of the real silver linings is that if you did bring value to your consumer, you can enforce the contract. If you found the house and you did exactly what you were hired to do, you're protected. They can't just get rid of you halfway through the closing. And I think that's a wonderful thing. It's this loyalty that we really haven't seen very often in realtor market before. So I think that's the real silver lining I'm excited about. We saw another one, Mike, where the agent used an old form. All right, so they used a buyer broker agreement. They thought they were doing the right thing, but when they looked at the date at the bottom, it actually showed like 2022, which doesn't have the four things that were mandated in that NAR settlement. What was the solution there?
We amended.
That's right. We amended it to include the disclosures, to include the language that was required. So it was dated correctly. It had the buyers. It just didn't have all the information needed. So we added it.
And the old form was on the NABOR website, and they ended up taking it off once we alerted them.
Yeah, and actually someone mentioned that in the comments, Nabor still has some of the old forms in here, even if they're not being updated or used anymore. That's a little scary. I think you just have to be paying very close attention, because even if Nabor got it right, your vendor, App Files, Form Simplicity, wherever else, they may not have it right. So be very careful what form you're using. Always double check the date at the bottom of that form.
Because
Always.
people are working like banshees anyways. There's just so much that everybody needs to do that they're bound to have forms that aren't put in there instantly.
How does a banshee work?
I don't know. I just made that up. They work harder than me, I'll tell you that.
All right, Mike. So that is the big thing, right? If you're brand new in 2024, you haven't done a deal yet, or you're trying to get back into it, that's really the big thing if you're working with a buyer. Now, how does that help a listing agent? If the listing agent has a listing contract and you're holding an open house, do you have to have a buyer broker agreement signed with anyone that walks through the door because you're now touring it with them? What do you think on that?
Well, actually, as I understand it, and you guys are the lawyers, for open houses, they don't need it, but it'd be smart for them to try to get one. But once they get into the specifics where they're negotiating and the people want to come back for a second showing, then that's a different animal. And I'll give you, I got one from left field, Christian. Don and I saw this morning. Very interesting. Think about all these NAR changes and how the boards rushed to get the proper wording in all the forms, and all these forms got created. What I'm observing for the agents that deal with foreclosed properties with banks, the banks don't have the wording in there, and a lot of those banks are using their own listing agreements, etc. So that's a new emerging thing that we're grappling with.
Yeah, so this is requiring a ton of resources. If you've ever worked with a bank on an REO sale, if you've ever worked with a relocation company that's hiring you to sell a property or anything like that, the key is having your broker review it, having an attorney review it to add in the necessary language into that form that they use. Banks, I think there is an uptick in foreclosures, and so you might see more of this. You just simply do an addendum and you add the required language that your brokerage requires. Usually they don't like it when you change their forms, but if you just need to add those things, that's not really a problem there. We saw that, I think, Mike, you had a listing agreement that was prepared by the bank. Is that right?
Right. Well, they want you to use their listing agreement, not the neighbor one or the far bar one.
Yeah. So in a perfect world, you would be able to negotiate with them to use the updated forms that you're more comfortable with. It's always better to go that route if you can, and then have the bank add whatever addendums they need. But if that's not the case, then you can do it the other way. You can basically have use their form and then add in your addendum. So either way would be fine. You just have to get to the important part of that listing or that buyer broker agreement.
We had a lot of these in 2009 when we had all the short sales and the banks were the sellers. And the banks are very unresponsive. The form might be drafted by their main office in one state and they're using it in all 50 states. And getting somebody to change it was difficult. Hopefully it won't be that way with these.
Yeah, in this case, we really have to comply somehow, some way. That's the key. So it's not a valid listing agreement until both parties agree to it. All right, so you've got your buyer broker agreement. You've got your updated listing agreement, which has certain disclosures that were necessary or certain changes to the form that were necessary. They call it compensation now. They don't call it commission anymore. That was an important distinction in the NAR settlement. The co-op or the splitting of commissions has changed drastically. Obviously, MLS is no longer to promote or market what the split would be. So people are having to reach out to a listing agent and say, what are you offering, if anything? And that has been a pretty massive industry-wide change because it was always kind of built into MLS. You could easily see it. You could even see it on Zillow or Redfin, what the other agent was offering as far as compensation. So now that that's not offered, we have to formalize an agreement between the two brokers. And that is the next part of this, which would be, let me share my screen again. You've got your broker compensation agreement. So there's broker compensation agreement for a lease. There's a broker compensation agreement for a purchase or a sale. And essentially what that is that the buyer broker and the seller broker are agreeing separately between themselves how much commission is being paid or compensation is being paid if the deal goes through. And it's usually based off of what the listing agreement says, or differently, if you're using a FAR form, they have a little bit different options. So you still have your compensation agreements, owner listing broker to tenants broker. So that's the lease. This one is seller to buyer's broker. So let's say the listing agreement doesn't specify money that's being given to the other broker. Well, the seller can agree. So the seller could sign something saying, hey, if we do a deal, I'll pay the buyer's broker X, a certain amount. You've got seller's broker to buyer's broker. So that'd be the listing agent agreeing to pay or split. Or you could do some balance of the two. You could actually have both. You could have one where the listing agent is agreeing to pay a certain percent, and then the seller himself or herself is agreeing to pay whatever else is being requested. It doesn't have to be one or the other. It can be both. And then, Dad, there's also one for concessions. Explain why are concessions relevant?
It's a separate category under the settlement agreement from compensation. It's for, prepays, repairs. Some portion of the concessions technically can be used for compensation.
Yep.
But it can't be conditioned that the concession amount be used entirely for compensation. Now, ironically, the settlement agreement does use for the word commission and compensation both. So I'm not quite so sure if it's a no-no to say that word or not.
Yeah, I don't know either. I think the concessions are used less frequently in my experience, but they're a great option if the listing agent or the seller wants to just pay the buyer and let the buyer use the money however they deem fit. So if, let's say, hey, if I'm the seller, I was allocating to give a certain amount of money to the buyer's broker, but I'd rather just give it to the buyer and let them negotiate. You could do that. Or if the buyer doesn't have a broker and instead they're saying, well, just give me a little bit of money towards closing cost. Okay, that's fine. So concessions would be a credit towards the buyer's closing costs, which the buyer can use any way that they deem. Interestingly, Dad, it's been a little clunky with how we actually get that signed paperwork. Do you get it before you make the offer? Is it kind of a waste of time? I've seen some people They even the listing agent has it available at the open house. They'll have a like a pre-signed compensation agreement at the open house, and the other broker just take it. And now they've got basically a one-sided offer to pay a certain amount. But if you don't have that, Nabor has the addendum. Let's see if I can share my screen again.
You know why I don't like that open house one, Christian? What
Yeah.
happens if the seller all of a sudden changes it? Now you
Well,
got a
that's the
bunch.
risk. Yeah.
Yeah.
So you could, if you have all these out there, and then later on your listing agreement changes or you get let go or something, it's still out there saying that you've agreed to pay this. So you probably want to put it time limited, or you want to be able to micromanage it a little bit more. I haven't seen that blow up on anyone just yet, but who knows? It
Have
could.
you seen the concession form being used yet, Christian? Because I see it. I don't see it working in the real world, to be very honest. I
The
mean, if I'm
credit.
selling my house, I'm not going to come out with a seller's concession. I'd wait till somebody beats me over the head with it before I give away money.
Well, actually, that's a good point. I see it both ways. All right, so I'll pause the screen share
Let
for
the
a
other
second.
guy go first, and what does it take to close the deal? And we can do concessions the way we've been doing it last year.
So I think if you are going to be way up front, you could simply offer that as part of the list price. So you list something $1 million is your listing price. You're offering, thinking, all right, I'll give certain amount to another agent.
Yeah.
Why don't I just offer it directly to the buyer and I'm not even going to talk to them about it, right? They want to use that to pay their own realtor, great. If they want to pay it towards closing costs, great. But that's the offer. I'm not offering more than that. The
But I
listing
would want to
agent,
make sure they're not going to come after me again after they have their inspection and want another concession.
well, I mean, what's different about that? Why
No,
not?
but I'm bidding against myself. My point. If my
Yeah.
proposal includes how far down, how much I'm willing to give you, just offer the lower number.
But are you offering anything to a buyer broker at that point?
I mean, if they ask, but if they don't ask, I'm not going to be the one opening my mouth and offering it.
So
My
on a
point. I mean,
listing agreement, and this is the interesting part when you get into strategy, the listing agreements already state, all right, what's the total compensation, and then how much are you sharing with the buyer's broker? Do you think you would want that to be zero? Or do you think you'd want to have that built into the listing agreement so that the listing agent has the ability to market that?
I'd probably want it to be zero because I can always modify it.
You
And
could always modify it. You could
you
always
know,
offer it.
and with the seller concession, if I'm going to give it, I want to make sure any provision in the contract that allows them to ask for repairs or credits for defective items is waived as well, because I don't want them to have two bites at the apple. That's just me. I'm curious how it's working in the real world.
So I think in the real world, they're two separate things. If you're offering, I think this is really cool because there are brokers who refuse to pay the buyer broker directly. They think that it's a violation of NAR. They think it's disregards what the DOJ wants. And so they're trying to just circumvent that and say, we're offering a certain percent directly to the buyer, but we're not offering compensation to their broker. If the buyer wants to use this concession towards their buyer broker, great, they're welcome to. If they want to put it in their own pocket, that's fine by us too. So it's not double dipping if then later they ask for an inspection repair. I see them as different, but I don't think the market has gone there yet. So most realtors are not doing that. Most of the time, the value is still in offering something to the other realtor. I don't see the value as going directly to the buyer just yet. Could change? Yeah, it could change. We'll have to see.
But you see my point. If you're selling your home for $1 million, you're going to also advertise that you're willing to give 30,000 in concessions. Why don't you just go to 970 if that's your bottom line?
Well, in most markets, they're getting a mortgage and they would rather the credit. So you can't use the credit towards repairs if you're getting it as a price reduction, that because your mortgage goes down with it. So yes, in this market, that's not always the case. People are buying and selling in cash, but I think that is where the challenge is. Remember, the couple of houses I've bought, I needed those credits to do the repairs, or I needed those credits to pay my my real estate agent.
Right.
So if I took a $30,000 credit from the seller and I owed $30,000 to my agent, I couldn't take that as a price reduction. I would have to take that as a credit so I could pay it.
And it's one way for your lender not to see a credit for a roof repair, which they don't want to see. They'd rather see a credit for closing costs, prepaids, and escrows.
Yeah,
Which
or
we
it could
always
be
preach.
payable to an agent. The lenders will let you do that without a problem.
Yeah,
So
I'm not trying to be difficult. I'm just curious how it's working in the real world. You don't, if you're selling something, you don't start out by saying how much you're willing to give to the other side. You wait for them to ask.
yeah,
You,
I think you could do it either way. You really
yeah,
could. It doesn't really change it one way or the other. But what's interesting, reason I wanted to show you the forms again is let's say you don't know what's being offered. Or let's say it's zero, like what you
right.
said, Dad, I'm not offering anything. I want to see your offer first. Let's say that's what the listing agent or the seller asked for. You have your addendum to sales contract compensation or addendum to sales contract concession.
Right.
So I'll pick one of them. This is compensation. This contract is contingent upon seller delivering to buyer a copy of a binding agreement establishing the compensation to be paid to buyer's broker upon the following terms. And you'd put in there listing agent to pay a certain amount or the seller agreeing to pay a certain amount.
Hmm.
So this becomes a part of the contract. It makes it a contingency saying, hey, we're offering you a million, but only if you're paying 30,000 to my agent, right? So now you're getting back to the
Right.
970.
But if I
Well,
were representing the seller, I would say if we're going to do this, one, because I don't want the seller to get angry at me. They have the right to come back and ask for repairs or credits under the standard neighbor contract, assuming that's what they're using. Maybe we want to address that at the same time.
I just see them as different things.
I want the client to know that it's possible.
That it's possible that they'll come back for more.
That they'll come back for repair issues because that's a separate part of the contract.
Yeah, no, absolutely. They're meant for different things. If you're
Yeah.
allocating a certain amount of money towards marketing this
Right.
that's the whole point. You're marketing the property.
But one strategy could be, hey, why don't we try to get them to waive any credits or repair requests at the
Yeah.
same?
And I think it goes back
But,
to the price.
yeah,
If you've lowered the price, if it really was a $2 million property and you've
right.
lowered it down to 1 million, then yeah, I want an as is with no inspection period and take it or leave it type thing. But if that is the price and I'm just taking those marketing dollars
Right.
and giving them directly to the buyer, they're not underpaying.
As
They're
long as
still
your
paying
client knows
top.
about it, I just again was curious if you've seen it and how's it working out and how are people using it strategically. Because I can see people not understanding it, and then another request comes in and blaming you.
So Sigrid mentions, I had the situation. The listing agent's brokerage advised the seller only to offer the amount of compensation as a concession. And the buyer will have to pay the buyer brokerage directly. Sadly, the listing agent and the broker did not feel very familiar with the NAR settlement agreement and what we needed to do with it. Actually, in my experience, the brokers that are requiring concessions and not doing compensation,
Hmm.
they're actually a little bit ahead of the curve. They are trying to predict what is ultimately going to happen, which is getting rid of clear cooperation entirely.
Yeah.
So that's why these brokers are feeling this way. They're trying to limit their potential liability if the DOJ turns and says, no, that settlement doesn't go far enough.
Well, plus they want the seller to be liable for the concession, not them.
Not necessarily. The listing agent can offer it as a concession. So they don't mind where it's paid. They
Yeah.
just don't want to pay the other broker. They could call it a concession. They could call it compensation, but they don't want to pay the broker directly. They want to pay the buyer. So it's really wild. I mean, you can even tell from our interaction that the confusion is the hard part because there are now 30 ways to do it and everyone thinks that they're right. So it's very much a
No,
challenge. The
I'm
simpler you
trying
can
to
make
think
it,
of,
the
can I
better.
use this to my client's advantage? That's all. Can I get a benefit out of this pain in the rear end process?
Yeah,
Uh,
that'd be great. I think that's
you know,
awesome.
I'm giving you $30,000 as a concession, and because I'm such a nice guy, why don't you waive your ability to ask for repairs or credits for defective items.
Yeah.
I mean, that's the
So,
best time to ask for something from the other side when you're giving them money.
so let's say the next situation is it's not listed. It's a for sale by owner. Do you still need a buyer broker agreement?
Yes.
Yes, you still need it, whether it's listed or not. But what do you do in regards to the seller and making sure that you still are paid a compensation?
You
You
use
have
a
a couple.
buyer broker to seller compensation form.
Well, you have that same addendum saying,
Yep. It's a
where
seller
you
paying.
basically the seller agreeing to pay buyer broker a certain amount, and you could put that together with the offer.
Yeah.
Or you use the showing agreement, which you do in advance, which says we don't have a brokerage relationship, but if I bring a buyer and we go under contract, you'll
Right.
pay X. So that actually hasn't changed. They modified the forms, they made it more recent, they added certain disclosures to it, and they changed the definitions or the terms that are used, like compensation.
I mean, I see that seller buyers buyer broker agreement being used with FISBOs as well as, owners who originally said, I'm not paying the other side anything. And they're looking at the current numbers on how long property's sitting on the market and they're changing their mind.
Yep. Yep. You could always have to readjust. You always have to be evaluating.
Right.
All right, so let's say you've got your deal, you make your offer, let's say you're like, wait, what, Mike, what were you talking about? Flood disclosure? Here's the form, right? So this is a new Florida statute. It was effective October 1st. First question, Mike, let's say you had a listing going back in January. It went live in January. Do they need to make this flood disclosure? This doesn't affect until October. Yeah, of
I always
course.
err on the side of caution. Better safe
Well,
than
yeah, I
sorry.
mean, if you're not sold yet, you got to do the disclosure. October 1st, you're still listed, you're still not closed. Go ahead, fill out the disclosure, send it over. It basically says a couple of things here. Very easy to fill out. Seller has or has not filed a claim regarding flood damage. Doesn't mean you filed a claim for flood insurance. It doesn't mean that it was um, anything. I don't even think it was like outside. It could be any kind of flooding, I believe. Is that right, Dad? I think
It's any kind of flooding.
yeah, I think it's any kind of flooding. So if your washing machine was the one that flooded, then you had damage. I had someone, the car in their garage got flooded, but the house was fine. And they said, well, do I have to say yes? Yes, you do, because
They,
it
they,
happened
they
on,
have that including but not limited to language,
well, it
which
says a provider relating to flood damage on the property. If it was in the garage, it was on the property. It may not have affected the house itself, but it did affect something on the property. Seller has or has not received federal assistance, would be FEMA assistance.
right.
For purposes of disclosure, the term flooding means general temporary condition of partial or complete inundation of property caused by the following. You know what? This might
This is
clarify.
all outdoor stuff in paragraph 3, it looks
I
like.
yeah, so maybe I'm wrong. This is not relating to a washing machine, but overflow of inland
Yeah.
tidal waters, unusual rapid accumulation of runoff or service, and sustained periods of standing water resulting from rain. See, that's what I was thinking. I thought maybe I was wrong. I definitely was wrong. But that you still have to fill out the disclosure. That part is clear. You might have, to disclose that different kind of flooding, like a washing machine, and a seller disclosure. That's something that would be a requirement under Florida case law, I would assume, especially
Well,
if
there are cases
material.
I've written about this in other districts. It's not been ruled on by the Supreme Court because they got this statute now. But to be safe, you don't want somebody citing the Miami case saying it could affect the value of the property and you should have disclosed it.
Yeah, so question for you, Dad, is this disclosure required for land sales only? Like, if it was only land, would you also have to use this form? It sounds a little silly, but you might as well, right?
I might as well be silly. Well, I always used Banshee already, so
Well, I know, I just
I
like,
would say yes.
I think you should. It doesn't talk about it being an improved property at all.
I,
It just says, did you file a claim? Did you have any damage that resulted in filing a
I mean,
claim?
my rule of thumb is if you have to ask your lawyer, do I have to disclose this? The answer is yes.
Yeah, yeah,
If
I
it
think
bothers you
so.
that much that you're picking up the phone to call us or whoever your lawyer is, it's an issue.
Yep,
Well,
I
if you think
agree.
about it, Christian, this might affect if they're buying land. this might affect the elevation of the home they're going to put on it if they knew that it floods from time to time.
Yeah,
So
I don't think it was written necessarily for land deals,
I
but
agree.
it's meant for all closings, at least in residential. So in that regard, you fill it out, and you're obviously not going to have filed a claim on vacant land. But what if you had a house on the property, it got damaged in a flood, you tear it down and you sell the land? Would you disclose that there was flood damage? Yes, you absolutely should, because that's exactly what happened.
Well, why not? I mean, it might be the seawall's too low, for
Well,
example.
it's obvious as to what happened. Usually there's a driveway that's still there. I saw a property this morning where there was still a mailbox. So you should probably just do the disclosure. It's not going
No,
to hurt
there's
anything.
no downside in disclosing if the house has been removed, and the potential upside is, the deal will go smoothly. You won't be responsible if the seawall's too low and they should have upgraded it. So if in doubt, disclose.
Yep, I agree.
Well, and
Honestly,
the buyer also thinks that you're being honest. I
yeah.
mean, the fact that you disclose that when you didn't have to, it gives them a little bit of comfort that I'm dealing with an honest seller.
Yeah,
Well, and
that's
I think a good realtor should then take that opportunity to say, look, this is what a good realtor does. This is my job to guide you. You've got to disclose it. And then I take over from there and sell it to the buyer. Give me all the information. Let's be open, honest. That gives me the best chance to sell the property. It's not a mark on the property unless you let it be. If you don't tell them, if you don't do anything about it, and then it comes later, that's a mark on everything. That's really hard to get away from in that scenario. Beyond that, I mean, there have been a lot of changes. There will be more changes specifically to the condo disclosure, the co-op disclosure, and the HOA disclosure. All those things are changing pretty drastically before the end of the year. Um, Specifically on milestone inspections and Sears studies. But those, at the moment, you still have the same forms. It's just that you realize that there's a lot going to be coming in the next 30 to 60 days. Dad, quickly, what's the milestone study? What properties does that affect?
condos three stories or higher, or in HOAs, co-ops.
I think they have to be a certain age, either 25 or 30 years
25,
old.
30 years, depending upon the location. A lot of them are getting hit with some heavy assessments. I've seen stories on Miami, how the market has really taken a hit. Some owners can't afford these assessments, so it might be an opportunity for realtors to pick up listings,
Yeah,
is one way to look at it.
yep,
Um, but this was after Surfside in 2021. Every member of the legislature in Florida voted in favor of it. Like 91 people died during that thing. They knew about $7 million worth of repairs that need to be done. They didn't do it. People died. So you have the inspection. They analyze the reserves, and the reserves have to be brought up to date at the end of the useful life of whatever component it happens to be. So that's why we're getting the heavy assessments, plus the repairs. If the initial stage of the milestone study is that an architect and an engineer walks around the building, if they see anything, then they can go do more intrusive investigations to see if there's something structural going on. But that's a big,
it's a big
huge.
deal. It's only condos. It's 3 stories or higher. Condos are working like crazy to get in compliance by the end of this year. Going forward, you'll have additional disclosures on condos regarding these Sears studies. You're going to have to provide the most recent Sears study report. It's going to be an additional item on your condo disclosure, condo document receipt. And actually, they are changing the forms to kind of mirror the way FAR bar forms look like. So
The
right now, FAR
condo
bar,
Nabor, isn't it?
say that again,
The condo one for Nabor. They're going to have an attachment like they do with Farbar.
just like FAR bar. Yeah. So FAR bar has rider A, which is the condo disclosure, and it has
Right.
lots of questions on there, and you have to check boxes, you have to disclose fees. I think Nabor is going to stop short of making you disclose fees, but it is going to have certain questions, disclosures that are required, part of the contract stuff. There's even stuff for like where there are multiple buildings within one master and you have to disclose, or actually, I think there's a new law about condo buildings, towers that have multiple uses. So like the bottom floors might be all hotel and the top floor might be residences. And you have to disclose that, the existence of that, as part of a new rule, a new statute through Florida. So the condo association disclosures are changing drastically, and it's going to look more like an addendum than what we see today. Today, we just have a disclosure receipt, which some people use and some people don't. This one you'll have to use. Everything's going to be in that
So
condo.
with Esplanade, for example, on Marco, you have to disclose there's restaurants on the first floor. It's not.
I think that's who it would apply to. Buildings like that where there are multiple uses within the same building.
Mercado, someplace with upstairs, they might have residences.
Yeah, or some of these like the Ritz-Carltons where you might have some of it is hotel and some of it is residential. You could
Right.
even have that new tower that's being built right on 41. I think the bottom floor is retail. There are going to be disclosures in that.
That
Um,
surprises me, honestly. I mean, you would think it's right in your face. There's a restaurant right there.
Yeah, but I think the purpose of it is to disclose where the costs are coming from and going,
Oh, okay. I
who
get it.
owns those? Are they members of the association or is it owned by the developer? Or do the members own that space?
Well, how are costs allocated? Because I know with commercial condos, it can be disproportionate to the square footage.
Well, sometimes the association owns those spaces and they rent them out to the people that are running the businesses there. And
Yeah.
so if you are buying in a building like that and that's foreign to you, all of a sudden you just bought a restaurant,
Well, I
right?
would want to know how the insurance is being allocated. Am I paying for the restaurants disproportionately high
Well, if
insurance?
it's vacant, who pays for it? The owners do, right? The
Yeah.
taxes, the insurance, the cost to rent it out, all that stuff is going to be on the owners, as opposed to that building or that unit is owned by someone, some individual, and they are on the hook for the up and the down of it.
You know
In
what I'm talking
fact,
about. Commercial condos, you can allocate according to risk, not square footage, and residential has to be
yeah,
square footage.
but it's all based on the condo docs, I suppose, in that case. So I think that's maybe the purpose for it is that if there are timeshares and something else, you got
Yeah.
to look at that a little differently than if it was commercial versus something else or just all
Okay.
residential. There's a little more risk or maybe less based on how it's put together. Mike, did you enjoy seeing us fight on that?
Very interesting. But you hit something earlier, Christian, that
What's a banshee?
it's something that's very spot on. And he brought up confusion.
Hey,
And
thank
the
you.
reality is, in town right now, not all brokers agree with each other on how to handle certain things, and not
Yeah.
all attorneys agree.
No.
What's happening now is we're going through a period where best practices will evolve. But it's very interesting to see, these topics you're talking about today, which are so pertinent that, it's interesting to see how each firm and each law firm handles these things.
Well, Mike, a part of like Christian and I doing it this way is lawyers frequently disagree. I mean, this
Yeah.
is not unique to him and I. And gradually he'll wear me down, and I agree with him on the as is, for example. I learned from his perspective. But lawyers argue all the time. We can argue about anything.
Oh
But,
yeah, we like it. We're good at it.
Yeah,
but with your practice,
just not with our
you
wives.
guys see volume. So, I
Yeah.
mean, a law firm or a title company that sees a lot of volume of real estate transactions, to me, have a very good sense on how things should be handled. And so that's why you guys are always my first call when I have something that, wow, I didn't never heard of this one.
I think at the end of the day, you really have to treat this like the job that it is. You have to put a ton of effort and time into it, and you have to stay on top. You have to stay up on top of everything in this because if you ignore it for a couple of months, it's going to be really hard to jump back into it because of how much regulation is being added, how much change in the forms and the process. I think it will be really hard for part-timers to continue doing this job. I
There's a lot
really
of
do.
strategy. I mean, your open house thing. I mean,
But
there was a
it's
lady.
so much more than that too, though. It's we've always had that, right?
Yeah,
This is regulation. This is
regulation, reading the
compliance.
contracts. Is it a big deal, or can I finesse this? Can I use it to my advantage?
Well, let's say you just don't do a buyer broker agreement. Oh,
You're screwed.
forgot. Didn't know I had to do that.
You
Totally
don't get
forgot I
paid.
had to do that. Can I do it now? No, you
No.
can't. The compliance issue on this is going to be really hard, and that benefits those who are paying attention regularly. Being in it and out of it all the time is going to be really hard to keep going. I mean, obviously, the hardest thing is to get customers. That is the hardest part. If you have the customers, you'll continue to do great. But if you can't keep up on the compliance side of things, this will bury you. And we're already seeing really good agents forfeit commissions because of mistakes on compliance. That's really scary, really scary.
I also think it's an opportunity if you're willing to put the work in to have a bigger market share because people will fall by the wayside. I mean, we've had
yeah.
downturns in this business and we lose competitors.
Yeah,
If you
well, and Yvette, she says, sounds like you're implying more work for attorneys and fees going up. LOL. Um, maybe, honestly, if you can pull this off, if you can do this job and you're really great at what you do, yes, you will command more and you'll be able to trounce over people that can't keep up. Absolutely, without a doubt. And that's in any business. This
But
is giving
the
people
other
an
side,
opportunity.
if you do a lot of closings, Christian, you're cutting down on how many transactions you can handle because you're spending a lot of time doing what the realtor does. So it's better for us to have more
Yeah,
transactions and have
it
realtors
is.
do the showings and explain all the various terms and all that stuff, and just handle the title work and meet the people and so forth. We don't want to compete. It actually costs us money if you're doing a lot of closings.
Yeah, I think it's hard to be great at everything, and we're certainly not hands-on in that regard. There's a reason why they're different jobs. They're not the same job.
Yeah,
Mike, thank you for your help. Dad, thank you.
you're
Enjoyed
welcome.
it.
Everybody, good luck. Now you all know how to do it. Now we're
There you
good.
go.
Take care,
Bye,
Christian.
guys.